Mr. Kennedy, has been the appropriate meeting notice published?
Yes, we have published the appropriate meeting notice, which includes the amended agenda to reflect the addition of agenda item H.
And I guess our first order of business is to get out the magic vase and draw names. Is everybody ready for that?
As ready as one can be.
I'm going to defer to my colleague here.
Let the newbie do it.
And let the newbie do it.
So
First,
there are 6 names in the vase. All of the current board members are on there, none of the old board members. Reed and I have checked it, so you're welcome to grab the vase or beer stein, however you want to refer to it.
It'd be quite a beer stein.
and the first name out is the chairman.
Vic Mannion.
Okay.
Way to go, Judge Mannion.
Yeah, this is Vic Mannion. I'm in Arizona, and I just agreed to serve because I was under the impression that all of the meetings were going to be by teleconference. So,
Well, you can participate by teleconference, but all the remaining 3 meetings after this are scheduled to be, with full board present. We know that you won't be able to attend until June
yeah, right.
in person.
So,
I would wait until we've drawn the next 2. The vice chair could run the meetings in your absence, in your presence, kind of like Judge Folke is doing now. It just means you have to spend a lot more time talking to me between meetings, Judge.
oh, if that's okay with the rest of the group, that's okay with me. But I guess I'll leave it up to the membership because I won't be there until the June meeting.
Why don't we follow Kevin's suggestion and go through the other 2 drawings and see what happens, and then we can discuss it.
Okay.
Are we ready?
Second drawing is for vice chair.
Harold Freilich.
Judge Freilich,
Yes.
are you going to be able to make all of the meetings in person? You've been chosen as vice chair again,
As I know, yes.
and we're good.
Okay.
Third is for secretary.
Judge Gerald Nickel.
Judge Nickel, you're the secretary.
Boy, am I happy.
Not near as happy as if you remain chair. Okay.
All right, that order of business is done. Do we have any personal appearances?
We do not have any personal appearances for this meeting. We normally limit it to just people with ballot access questions, but no one has submitted a request. Our ballot access issues, we didn't get any challenges, as you'll learn when we get to agenda item G. So there is nothing to, no one to schedule for item D.
Okay, let's go to E.
This is Judge Frankie. I just wanted to welcome Judge Mannion, Judge Lineweber. If we were having a personal meeting, we would have a big ceremony, wouldn't we?
Yes, we would. We'll wait until next time.
The robing ceremony or something. I forget what it's called.
Exactly.
But certainly welcome to a teleconference.
Yeah, thank you. Happy to be here.
Okay. Thank you.
All right, let's go on to E, the agency transition report.
So this is a report that I provide to board members. It's on page 4 of the materials. It's really primarily for informational purposes. If you have any questions, we've had 2 in-person meetings with the Deputy Secretary of the Department of Administration. We have another one scheduled for next week. I have Sherry and Reed as the transition team. The management team does a lot of planning, but Sherry and Reed attend the meetings, and we are, putting things in place, as you can see from the report, with respect to getting the transition moving. At the the meeting of the Presidential Preference Selection Committee last week, Speaker Voss indicated he hoped to have appointments made by the end of January for the new commissioners. Under the provisions of Act 118, the new commissioners may sit on the board as non-voting members for any meeting after February 1st if they are appointed.
Any questions? Hearing none, let's move on. I guess there's one other thing that we ought to note, though. Because of the number of commissioners that may be involved, we probably will not be having our meetings here. Is that correct?
That's right. We've reserved rooms in the Capitol on the assumption we may need more space for the august body that will be overseeing these meetings.
Let's move on to F then, delegation of certain authority to Director and General Counsel. Mr. Kennedy, is there anything in addition to what we granted last year?
This reflects the changes that were implemented last year, which basically had more to do with the level of approval of contracts. And that's described in my memorandum. Starts at page 6, but the statutes specifically allow delegation of certain actions. Where that will be important in the next couple weeks is if there are any challenges to local election officials' decisions regarding ballot access. Before they can go to court, they need to file a complaint with us if they're aggrieved by the decision of the local election official. And under those circumstances, the election administration staff would review that, prepare a opinion and order, which I would then consult with Chairman Mannion to decide whether to issue that, and if it's okay with Chairman Mannion, we would issue the opinion and order, or he could direct a special meeting of the board if he thinks it warrants it. At the moment, you know, we're tracking a handful of local issues, but we don't know if any of them will make it to our level. Again, we didn't have any, as you'll find out when we get to item G, any issues with the candidates who filed for state office.
With that understanding, is there a motion on this issue?
This is Judge Nickel. I would move the approval of the motion as set forth on, I believe it's page 9 and 10 of the material.
Is there a second?
Second for Mannion.
We're going to give it to Freilich. He got there ahead of you, Judge Mannion.
Oh, okay.
Is there any further discussion? All those in favor of the motion, say aye. Aye.
Aye.
Any opposed? It passes 6-0. Let's go on to G. We have an election administration ballot access report.
Before you go on,
Yes.
Kevin, will you be doing the summary of your discussions with the chairman as originally set forth by Judge Nichols?
I think that's a good practice to continue, yes. So
Okay, very
so
good.
whenever Judge Mannion and I have a conversation about anything between meetings, I will memorialize that in an email to board members.
Very good.
If I can digress, Judge Nickel, for a minute, going back to the transition, Kevin, one of the concerns that I have is, from being there at the beginning, is the administrative code and those provisions that directly relate to the agency or will be to the new agency. Does the law provide that those are automatically approved and made part of the new agency? I should say agencies.
That's one of the things we're going to be talking with. Nate hasn't gotten his assignment yet on this, but we'll be talking to the Legislative Reference Bureau, which is responsible for that. Last time, they simply took the existing codes and combined them into a new chapter, G.A.B, and carried them over. As you know, the board didn't approve certain ones. It took them a while to remove them from the code. In fact, they didn't remove them until last year on that. But We anticipate that they will split the existing rules into those related to elections and those related to ethics and campaign finance. And they'll have separate labels on that, but that's pretty much an administrative function that's been done before. And then anything that's existing will get carried over. We have a number of rules in the promulgation process. We're waiting for approval of scope statements from the governor's office. I anticipate there may be some additional push to get some things, at least in the pipeline between now and June, from this agency.
Thank you.
Any other issues, gentlemen? Okay, can we go on to G then? Ballot access report?
Mike Koss will handle that.
Good morning, board members. Diane Lowe would normally be presenting this material as she drafted the memo, but she is out with a bug this morning, so she asked me to cover it. I just wanted to walk through a few points in the memo that starts on page 11 of your board package. As board members know, this is one of the primary decisions that the board is responsible for making at its January meeting, which has to do with certifying candidates for the spring election ballot. So our team of election administration specialists reviewed nomination papers. The circulating period started in early December, and the deadline for filing nomination papers was last Tuesday, January 5th. There were, I believe, about, if my math is correct, 47 offices, and we had 63 candidates file nomination papers. The process went really smoothly. I think partly because we have a good system down, but also just by circumstance, this is a little bit unusual in that we did not have a lot of candidates wait until the last day or the last 2 days to file, which typically happens. In fact, I think this year, no candidates filed on the last day, the deadline on January 5th. We had one Supreme Court candidate file on Monday, the 4th, but we were able to review those nomination signatures over those the next day. We do have a policy in place where we review all the nomination papers within 24 hours of submission, and that allows the candidates an opportunity to rehabilitate signatures if our staff has struck signatures and they would fall below the required threshold. We had one deadline that was extended for a Dane County Circuit Court judge position because that incumbent had not filed a notification of non-candidacy. That was Judge Trupus in Branch 3. That extended the filing deadline for that office to last Friday, but no additional candidates filed. So that was an incumbent who did not file either nomination papers or the notice that he would not run. We also had no challenges filed. The challenge deadline was Friday. If we had challenges to nomination papers, the incumbent or the candidate would have had an opportunity to respond to the challenge, and that deadline was last evening. And so that made it a little easier on our staff not to have to assess any challenges and prepare those materials for the board. On page 12, we set out the requirements for the number of signatures required for each office. As I said, there were no candidates who filed with us that fell below that threshold after staff review. We always try to note any type of irregularities, just so that the board is aware. We noted a couple of them this year. The first one on the bottom of page 12 had to do with how an office was referred to. And the board had dealt with this question last year in a little bit different format, but in essence, the candidate indicated that the office was simply judge, rather than identifying it as Milwaukee County Circuit Court, with the but the branch was listed. So, and based on previous decisions of the board, staff felt that that did not mislead any signers and that that was substantial compliance with the statutes. We also noted a problem that we noticed last year for the first time because of the printed name requirement for signers. It appeared that some nomination papers for candidates for Milwaukee County Circuit Court, on the face of the papers, look like printed names may have been written in by the circulators. And the board last year directed staff to write to those candidates and just alert them to what the law is, which is that the signer needs to print their name. We don't have any, definite evidence about who printed these names, and there were no challenges, and striking those signatures would not have affected their qualifications to be on the ballot. But we just noted that that happened again this year. We are sending this year a letter not only to those candidates, but to the clerk of the court for Milwaukee County to distribute to all Milwaukee County judges, so that we hopefully will not continue to see that problem. There is going to be a primary in the Supreme Court. As you know, there are 3 candidates who qualified. We also have primaries for only 4 other offices, which are circuit court judges in Iowa, Kewaunee, Portage, and Walworth counties. We have, all of the candidates have filed their statement of economic interest. That deadline was Friday, which was after this memo was prepared, so nobody was disqualified for that reason. We have a recommended motion on the bottom of page 13, which would incorporate the list of candidates qualifying for the ballot that is attached. Those candidates would be the ones where the last column indicates APR or approved.
Pending. Approved or pending.
Approved or pending, I'm sorry.
Any questions for Mike?
Mike, this is Frankie. My recollection is that a circulator can write in the community or municipality, and I think also the address on a nomination form. But does the statute specifically say the signer needs to sign and print their name?
Yes, when that law was passed for the printed name requirement, it does specifically say that it is the signer that needs to print the name, and that question has arisen with also with some local clerks who are reviewing nomination papers, because sometimes those signatures have to be rehabilitated, and we remind them that an affidavit can be filed if a printed name is missing or not legible, but the affidavit needs to be submitted and it needs to be signed by the person who signed the papers, not by the circulator. So.
But can the circulator add information like address and community?
Yeah,
As long as
yes, he can.
Yeah, our rules specifically authorize.
Maybe that's where the confusion comes from. I certainly don't want to embarrass anyone, but did we ever get a response last year? Did anyone question the advice that the circulator, or rather the signer, obviously needs to sign and print their name?
No, and I don't know that we really asked for a response except that they could call us with any questions. But I think the letter was intended to advise them about what the law was and to just make sure that everybody complied with it in the future.
Is the letter going out this year going to say anything different than we said last year?
Well, I think that we may update it and say that this is a problem we've seen in the last 2 years, but I think the substance will be mostly the same.
Although we are going to bring the clerk of circuit court into the mix in the communications. And I think one of the issues is that in Milwaukee, because there are so many circuit court judges, it's sort of a insider's game. People sort of talk amongst each other about how to circulate papers. And borrow each other's forms and things like that. So it's not unusual. It's, again, it's just something we've noticed. No one's filed a challenge to it, and we think it's something that we ought to try and change the culture by getting some more education out to that particular group of candidates.
Well, and I think we will, we'll make sure we follow up, with a phone call to the clerk to make sure it's being distributed and that any questions are directed to us. I'm not sure if we did that last year or anything in addition to just simply sending the letter. I would just also finally note, as Kevin mentioned, we have not yet received any appeals of decisions at the local level. We may still see some of those. We've had conversations with some clerks and some candidates or their attorneys about local decisions, and we handle those as they come in. We always look at whether it is something that is going to affect the primary ballot. Oftentimes, it's only going to affect the April ballot, but we try to get those decisions back to the local clerks and candidates as soon as we can.
Any other questions? Is anybody prepared to make a motion as to the proposed or the recommended motion on the bottom of page 13?
Bottom of page which?
13.
13.
You're hurting our ears.
This is Judge Nickel. I'll make the motion at the bottom of page 13.
Is there a second to that motion?
I'll second the motion.
I think
Frankie?
we can remove the contingencies that are stated there.
Yeah.
And just simply approve all those candidates that are listed.
Mike Haas is suggesting that we get rid of the,
Ballot access challenges
since there are none.
and the,
I think we should, even though I seconded this, I was trying to we should clarify that this isn't contingent on some possible future ballot
Right.
challenge.
no, all the contingencies have been removed. There have been no challenges, and everyone who was supposed to file a statement of economic interest has filed one.
Yeah, so I think maybe, what if we get rid of the first phrase up to the comma
Right.
and just capitalize T for the board and make that the motion? So it says the board certifies ballot status for the 63 candidates listed as, quote, approved, end of quote, or quote, pending, end of quote. Would that,
I'll accept that as a friendly amendment.
So will I.
okay. Any more discussion? All those in favor, please say aye.
Aye.
Aye. Any opposed? It passes 6-0.
So we will send out a certification to the county clerks after this meeting, confirming the candidates that have qualified for the ballot and the ballot order for which we've already drawn the names on that, so.
Are we ready to move on to H, the registration and reporting of segregated funds? It starts at page 25, in addition to which we got a letter signed by Senator Fitzgerald and Speaker Voss. At least I hope everybody got it.
Got an email.
Yeah,
Yes, it was in an email.
It was in an email. The first email that I sent did not have it as the attachment, and Reed corrected that.
We need a motion for reconsideration of the prior motion that to do nothing on this issue.
We did nothing. We had a discussion, and I think the consensus was pretty much let our successor take care of it. That's my recollection.
This is Frankie. I asked about minutes earlier, and one of the reasons was I was looking through the long list of campaign finance change recommendations we had for the December 15 meeting, which was tab E, and this item, I believe, was number 4 on page 20. Is there a record of what vote we took? And I think I remember, I'm not sure I remember how I voted on this, but I'd like to know if I'm being asked to change my mind or whether I dissented on this or maybe abstained because I felt we were moving too quickly on interpretations of this new law.
It looks like Jonathan Becker may have an answer for us.
Well, let Reed, since he's working on the minutes, speak first.
Yeah, the minutes aren't done yet. However, Judge Vokey made a motion to approve the staff motion, and that died for lack of a second.
Okay. I died for lack of a second.
So there was a lot of discussion about it.
Was this after a discussion that included some thought that we needed to go slowly in interpreting these new laws? And if that's what it was, then it wasn't really a decision that there was no reporting requirement. It was simply no decision.
It was no decision, but let's let Jonathan Becker add whatever it is he's got.
And maybe I should give some background for the new members as well. Under the new campaign finance laws, political parties and the 4 legislative campaign committees, and those committees, each party in each house of the legislature has a legislative campaign committee. Under the new legislation, those legislative campaign committees and political parties may establish separate funds that may take contributions not subject to the same source restrictions and limitations as the parties and committees would otherwise be. The separate fund money may only be used, however, for limited purposes, essentially administrative purposes, or such as including building an office building, but essentially administrative purposes, not to give contributions or not to make any sort of independent expenditures from. In creating those separate funds, there was no separate language in the new statute about the reporting of those funds. We at staff understood, though, or believed we understood, that being received by the legislative campaign committees and political parties, they still needed to be reported. We recommended that the best mechanism was simply to report those separately in a separate, it's hard to explain how the electronic system works, but rather than reporting those receipts and the expenditures of those receipts intermingled with all the other reporting of receipts and expenditures on one report, there ought to be simply a separate report. And we said so in order to get that separate report, the separate funds should register separately. We did not mean that to mean that they would really be treated as separate committees subject to the filing fee that all committees are, but simply as a mechanism so that the reporting would be segregated. The reporting of the separate funds would be segregated from the main reporting of the parties and legislative campaign committees. The board did not vote against that. They simply did not, there was not enough votes for it. As I recall the discussions, Judge Barlin, the 3 judges that expressed concern with that approach were Judge Barlin, Judge Lemalis, and Judge Franke. I believe Judge Barlin's concern was that if there's an issue with the legislation, the legislature should fix it. And I think Judge Lemalis was concerned, as I recall her, what she said, with just going beyond what the statute
She didn't want to embroider the statutes.
Right, but now I think we have a clear indication from the authors, including not just the authors, but the agency that wrote it, that the intent and understanding was always that these should be reported. And we think, and we still think that the best way of doing that is to report those separately, as opposed to intermingled, with the other reports, and that's what we're recommending.
Let me ask you a couple of questions if I could. Are you making the same recommendation to the board as you did last month?
Yes,
And is that recommendation, in your opinion, supported by the memorandum done from Joseph Creye, Kreye?
yes,
And is it also backed up by the memorandum by Attorney Whitweiler?
yes,
And also backed up by the letter that we just got
yes.
from Misters Fitzgerald and Voss?
Yes, and just so the board knows, we had, we at staff are not trying to make things up, and on some of these issues, we had conferred with the aides for Senator Fitzgerald and Speaker Voss, even before we came to the board. And so, and it had been our understanding that they had supported staff's interpretation at that time. And so, looking at what we now have in writing, we believe that we have been consistent with them, and they are being consistent with us.
Could I ask Reed to read back the motion from that meeting? I don't have a copy of it.
I don't have a copy.
Well, I believe it's on page 21. I can read it, but I'm confused because that recommendation addressed whether segregated funds had to separately register or not, as well as whether they had to report contributions.
That's right.
And I think the issue we're talking about now is whether the political parties or the legislative campaign committees need to report this information, either money into the segregated fund or money out of the segregated fund.
So
and those are obviously close but distinct issues.
They are distinct. Reporting is one aspect of it. I think staff was remiss in not being entirely clear about what we meant by registration, because all that was in our minds was the mechanism for those reports. And the reason we wanted to use that mechanism, because the other mechanism is simply to say, oh, just include it in your report. But it would have been difficult to then, for the public, for us as auditors, for anyone to figure out what monies were in the segregated funds and what monies were not, and whether the parties or the legislative campaign committees are violating limits and source restrictions, because the report of that would have been intermingled with other funds.
Let me ask
Now, one of the
another
problems,
question.
by the way, in the intermingling is we could probably have our IT developer change our system to somehow enable the separate reporting of those receipts and expenditures, but that would be an expenditure of funds that we didn't think was necessary, as well as taking some amount of time for our developer to make that change. And so we thought the quickest and easiest is we'll just have the parties and the legislative campaign committees who decide to create these segregated funds simply to, I hate to use the word register, but to note, to register, to inform us that they have this separate fund and that the activity of that fund will be reported separately.
Do you need to change the wording of that proposed motion in any way, in your opinion?
Well, we could, if it makes the board more comfortable, we could change it from register to note a separate
Can
fund.
somebody do that right now, so we know what?
Do you get the motion
The motion?
from last time? Do you want to see it?
Yeah, I do wanna
It's
see
not
it.
in the
But
memo.
Jonathan, when you
Judge
Wilkie asked
Frankie?
earlier whether the memos we received.
Judge Frankie, Mike Haas just gave a copy of the motion on his laptop to Jonathan, so he's looking at it right now.
Okay, so what we had asked is that they use the same form and simply, rather than saying Republican Party of Wisconsin, say Republican Party of Wisconsin Segregated Fund, and that would carry on with the other political parties as well as the legislative campaign committees. So I think we're still asking that they somehow note on a separate, on the form, that there is this, that they have established a segregated fund, and that the report of that, of the receipts and expenditures will be reported as part of that paperwork, as it were.
Can you, right now, state a proposed motion to us that we can consider?
The board should direct staff to require any segregated fund to inform the board using the appropriate form that they have established a segregated fund and report all activity and cash balances separately for that fund.
Judge Frankie, do you have more questions for Jonathan?
I have lots of questions, but just as now stated, Jonathan, did you mean to say that the segregated fund has to report, or the political party has to report?
They're one and the same, well, someone has to report. I don't think it matters who actually sits down at the typewriter, or not the typewriter, that shows my age, at the computer and do that. The obligation is, in fact, on the political party.
Well,
Yeah, and that's the distinction, I think, that's getting lost when we treat the segregated fund or like a separate entity. And the statute is very ambiguous on this, in my view. And we can talk about that, but would it be possible to circulate the motion in writing by email so we can see exactly what we're voting on?
sure.
Okay, so let me
Or restate it,
Let me
because as
restate it.
stated, we're imposing a requirement on this thing called the segregated fund.
No.
And
let me
that's the way it was stated a moment ago.
okay, let me rephrase then. Let me rephrase and read.
I think we lost somebody.
Let me do just a quick check here. Nickel,
I am.
Freilich,
Aye.
Frankie,
Present.
Mannion,
Lost the chair.
We lost the chair.
We lost our chairman.
yeah.
That doesn't bode well for future meetings.
Well,
If John could
he may
dictate
call
the
back.
motion again,
I can reach out to him on his wife's cell phone.
Let me dictate what I think, and I'm just working this through here, because I understand the concerns, and I want to address those.
So go
So the
slowly in
board
phases.
should direct staff to require any political party or legislative campaign committee,
Hold on, party or
legislative campaign committee, that establishes a segregated fund to inform the board.
funds to,
They do that by reporting. They don't have to inform the board. When they send in their information, the report is there. You're going through an extra.
Judge Nickel, are you there?
I am.
Judge Freilich?
Yes.
Judge Frankie?
Present.
Oh,
Judge Mannion's back.
This,
Oh,
this
Judge-
is Mannion. I got cut off somehow, so I'm back again.
all right, thank you.
Yes, it is our recommendation that they take that extra 5-minute step. And that, and if the board disagrees, then the board disagrees, and that's not the way we proceed. But it's staff's recommendation that they do inform us that they have established a segregated fund, and
It's
that,
automatic when they file a document showing you the funds.
That's essentially what we're asking.
that's essentially what we're asking. The problem is for the system to enable them to file that separate document, they have to have something that it attaches to electronically. We don't have I mean, if this was paper, we would simply say, attach this extra document to the report that you file. We don't have that. We can create that electronically, and we can do that expenditure, and we have no problem with that. And that, we could create that as an addendum or some attachment to the report of the party if the board feels more comfortable with that. This is just simply an administrative, technical issue. It's not, in our view, anything more than that. But if the board is uncomfortable with having, the way we would have recommended it is that a member of the public interested in the activity of the segregated funds could go to our system and do a search on show me segregated funds, and they would pull up just the activity of those funds of the parties. We don't have to do it that way. We could do it and have our developer develop addendums to the existing reports and just be part of the party and legislative campaign committee reports. That will take a little bit of time, but we should be able to do it, I think, before the next reporting deadline. It's just gonna cost some extra money, that's all.
Can you make, once again, can you make the motion, and then can we send it via email to the other 4 judges?
I was in the middle of typing when the questions came up, so I'm still in the process of
Okay.
doing this here.
In the form that we have recommended, the motion would read, the board should direct staff to require any political party or legislative campaign committee to inform the board of the creation of a segregated fund.
To inform the board what?
Of the creation of a segregated fund and to report the activity and cash balances of the fund separately.
And that's supported by Cray and Wittenweiler and Voss and Fitzgerald?
I think so.
Well, I think it's important to recognize, if I'm right, that the issue of those memos the issue of the memos is different than the issue raised at the December 15 meeting under that Part 4 recommendation in terms of who is being required to register and report. And it's an important distinction. I'm a little uncomfortable requiring and something to register that isn't clearly required to register by the statutes. And that's why I've been trying to parse out this language in terms of what it is we are requiring and going with what I see as a sort of strict construction of the statutes. And I understand the administrative problems that might result, but this segregated fund is a strange thing. It's not really authorized or identified at any point in the statutes other than one, and it appears in the context of a section that is allowing unlimited contributions, and it refers to contributions to a segregated fund established by. So there's only this implicit authorization for a segregated fund that's established for a particular purpose, and there's no other section that defines it or says that it exists. So my starting point would be that then the only requirement can be on the party creating that entity to do any reporting, and is it not enough to say they have to comply, that the political party has to comply with 11.0304 and do its reporting under that section, including whatever activity there might be in a segregated fund?
I think we may have lost Judge Mannion again, so let's once again take a roll call.
No,
No, you're there?
Mannion is here.
Nickel?
I'm here.
We know Judge Frankie's there. Judge Freilich?
Here.
Okay.
Okay.
Let me just add one thing, Judge Frankie, to sort of put, I think, your concerns in context. You know, because the writing of this stems from the Barlin 2 decision, which was to impose the least restrictive requirements in terms of registration and reporting requirements. And and the way the law is written, an entity that is clearly subject to registration a political party committee or a legislative campaign committee is allowed to have a separate account in addition to their political account, where the contributions and spending from that account are treated differently than the money it would raise separately in terms of no contribution limits, no source restrictions with respect to corporate contributions or the size of an individual's contribution to it. And what the staff, I believe, is proposing in its motion is, all right, Republican Party or Democratic Party or Legislative Campaign Committee, when you register, you have to tell us your regular account. If you tell us the separate account, if you establish a segregated account, tell us that also. We're not getting any more information other than the new account number and that it's a segregated account under this provision. And then when you file your reports, you give us two sets of information. That's essentially what we're asking for in the motion. And when we were referring to registering and reporting last time, it was simply telling us you have this account, which I think is consistent with the Barlin 2 decision of keeping it as least restrictive as possible, even though this is an entity that clearly under Barlin 2, those concerns aren't quite as important. So when we say register, it's really just tell us what the other account is, and that's why I think the motion now reflects that. But I think that's what we were getting at, is we need a mechanism for them to tell us you have this account, and we'd like them to make sure they're reported separately, because that seems to be consistent with the intent of the law and is certainly the most informative to the public.
We have a question.
Well, I just want to comment that, and also as someone who's new to this whole discussion, it seems to me that the confusion arises out of the use of the term registration, but more so the use of the term fund or funds, which of course a fund in some sense can be a separate legal entity, not in this case. So I think if you proceed as Mr. Kenny suggests, where you say it's an account containing segregated funds, I mean, it's just a bank account, right, or some kind of financial account. And if that's made clear, then I think the confusion kind of goes away. If it says it's an account containing segregated funds, it's clear that we're not talking about anything that can be a separate legal entity, which could conceivably be required to register in the technical sense of registration.
That's correct. That was certainly what was always in our minds.
How does that
And we may
jive?
not have expressed that very as clearly as we could have.
How does that jive with what you were concerned about, Judge Frankie?
Well, I understand it. I think it's, I don't have a problem with the way it's been stated most recently, if that answers your question.
By Jonathan? You're referring the way that it was just stated by Jonathan Becker, you don't have a problem with?
I believe I do not have a problem.
Should we take the time to print this up and send it?
It's already been emailed
It's already
to
been
the
done.
others. We can print it out if you want to look at it in print.
Can we, for the two lists that are here?
Sure. Do that.
A third of the board needs to see it in hard copy. Rich is going to get it, if you tell him.
Just a second. Should be on the, should be on the printer out there. You might need to make a second copy.
Are there enough copies for me and Kevin and others here?
Just tell Rich to run it through the copy.
This, I guess, changes the way I would focus on it, and I don't know that I have an objection or a problem, but I would just point out that what we're doing, if we approve this motion, that goes beyond the strict language of the statute, is a requirement that a political party report the activity separately. I don't think I have a problem with that. The 0304 requires that a party report all contributions, disbursements, and obligations received, made, and incurred by the political party. 1104 allows for contributions to be paid to a segregated fund established and administered by a political party for purposes other than making contributions to a candidate committee or making disbursements for express advocacy. That's the end of that section. So what we're imposing that is not explicitly authorized by the statute is a requirement that these things be reported separately. Is that a fair summary, Jonathan?
Yes, yes, and I think, you know, I actually appreciate the board helping us clarify our, our thinking as to what we meant, and you're absolutely right. It's not a separate entity, it's simply a fund that is owned by the party, but it's owned separately and must be kept separate from all of its other funds. And we're simply asking that the activity of that fund be reported separately, and we believe that it's required to be reported by the statute, and certainly that was the intent, and then we're just asking that rather than jumbling it in, since it's gonna be in a separate account, bank account anyway, that it be reported in a separate fashion.
We're just getting our copies of the proposed motion.
Thanks.
It's on the email.
Yeah,
But we don't get email because we're not allowed to use our phones here because they make noise.
Oh,
Mike, thank you. Time out.
Anything else? Any other questions before I ask for a motion?
is that the fund to which that limitations apply also?
Yes, limitations on what the money can be spent for, yes.
Or how much can be given?
No. There are,
Judge Mannion.
there are some limitations on what can be given, depending on the source.
Right.
Corporations, it's 12,000. Individuals, is no limit.
Native American tribes.
Right, 12,000. So there are both some limits on entities that could not ordinarily give to the party itself, and then with respect to individuals there's no limits at all as to the amount an individual can give.
Steve is falling
Right.
apart.
Now, I'm going to have a question about what advice we were giving out and whether it was in writing or orally, but I see that as separate from what we're deciding today.
We've not given out any advice because the board did not direct us to do that. So there has been no advice. The legislature got involved in this because they were watching Wisconsin Eye.
well,
last
that's not
time.
entirely true, John.
Partly
In
true.
response to questions, we said there is no reporting requirement,
Well-
which I think was the wrong answer when we gave that answer, but that did emanate from our office, and we've been scrambling to try and correct that.
Yeah, certainly whether it's correct or not, the implication in the memos we got is that the board made a certain decision that neither the segregated accounts as a separate entity or the political were required to report things, and I'm interested in whether that's accurate at all, and whether it was given out orally over the phone or in writing, or whether someone simply inferred it from watching the meeting and misunderstood what happened.
In response to press inquiries, it was stated that there was no reporting of this activity, the segregated activity, and that was an incorrect statement when it was made. I think the answer was, we haven't addressed it, which should have been the answer, but what came out and what spurred all of this response was the position that was articulated with questions, and it wasn't, I don't think, advice to any particular party, was simply, well, we don't see that there's a reporting requirement because the board took no action, and that was probably not the way we should have phrased it. We should have said, the board hasn't acted on this, and left it at that.
Kevin, are you referring to like a press conference the day of that meeting, or just after the meeting?
It was just inquiries that came up from I think members of the press.
Well, I mean, there was initially some communication between staff and some of the parties, I believe. And then, after that happened, then we got some press inquiries.
Jonathan Becker is saying no.
I don't, I thought the first contact with us was from the legislative staff. We did not reach out to legislative staff. Rich, was there some communication?
I had two communications. One was Wittenweiler's office, and one was DPW, I believe, asking if there was any disclosure requirements.
Have a seat. Judge Frankie, do you have any questions based upon that statement?
I don't, if you heard that, Rich Boring, our lead campaign finance auditor, said that he was asked by Democratic Party what they should do, and by,
An outside, Mike Wittenweiler's office as an
Yeah.
outside consultant.
right, and our answer was there was nothing to report. Which,
But just maybe to make it, if I make it more specific, for example, in the Godfrey and Kahn memo, the last sentence of the first paragraph says GAB staff has advised political parties and legislative campaign committees that no registration or reporting requirements arise until the legislature acts or the GAB decides to address the issue. And there's a footnote saying GAB staff has confirmed this position to us by email. And I'm just wondering, I'm trying to get a handle on what written or oral advice we gave out to anybody asking, whether it's the Legislative Reference Bureau, or legislator, or a political party or campaign committee asking, what advice did we give out orally, if it can be reconstructed, and in writing, saying that no registration or reporting requirements apply.
The email that I sent out to them was in reference to the meeting. They were asking what action the board took at the meeting, and basically that regarding the, staff recommendation, and stated that the board did not act on it, did not require registration or reporting at this time, but the legislature or the board could review this at a future date. It did not state that it was a done deal. It basically, until they look at it at a future date, currently it stood as no requirement to register and report as of the last meeting.
And I think that's an accurate reflection of what the board did, because we had not separated out those two issues for the board, and the board took no action on either of those. So we had no guidance one way or the other, and that's all we were telling people, as I understand it.
Well, I guess, and maybe we're splitting hairs here. I don't agree at two levels. One, we took no action, which is not the same as saying there's no requirement under the law. And secondly, what was proposed had to do with requiring segregated funds to register, and unless the discussion reflects it, didn't involve any kind of decision as to what a political party or a legislative campaign committee was required to do. So I guess I'd like to see the email and just make sure we're as careful as we can be when a position of the board is stated.
Any other comments or questions? Are we prepared to consider the motion?
Yeah, I'd like to make a comment with regard to the
Please.
proposed motion. Well, once again, and I don't have the statute before me, and this might go off the rails for that reason, but it seems to me, again, based on the earlier discussion, that the motion would be less confusing, perhaps, if it said, rather than the board directs staff to require any political party or legislative campaign committee that establishes a segregated fund, to instead say that establishes an account containing segregated funds, plural. And then the rest of it, I think, would read fine, but it would make it clear that we're not talking about a legal entity of any kind. We're talking about an account containing funds that are held separately for the purposes. And then after that, if you call it a segregated fund, it's clear that we're just talking about an account with some money in it and not a separate legal entity.
With that additional language, are you prepared to make a motion?
I am.
Then I've got a question. Are we requiring that the segregated fund be a separate account as opposed to just account from an accounting standpoint, separated money?
Yes. And I think that was always the intent, and I think that was implicit in the idea of creating a separate segregated fund in the statute. I mean, when the statute talks about allowing them to create a separate segregated fund, I think they're referring simply to an account that's under the control of the entity.
I would move to amend the proposed motion to strike the phrase "to inform the board of the creation of a segregated fund," and then simply require that the activity, that there be a report of the activity and cash balances of the segregated fund separately. It accomplishes the same thing, I believe, without establishing some additional requirement as to when you have to inform the board. All you have to do is report the activity and cash balances of the segregated fund separately.
Do you have any objection to the proposed additional language by Judge Lenneweber?
Do I?
Yes, where he talked about establishing an account with segregated funds.
I would leave it in the statutory language, so I guess I do, that it just refers to it as a segregated fund.
So are you prepared to make a motion? Judge Frankie, I'm referring to.
There's no second to Judge
There's no
Leineweber's
second.
motion. So,
Welcome to the
I would move that we direct staff to require any political party or legislative campaign committee that establishes a segregated fund to report the activity and cash balances of the fund separately.
I'll second that, Freilich.
Is there any discussion?
Can Judge Frankie restate the motion slowly so I can get it down, please?
Judge Frankie, slower.
I move that we direct staff to require any political party or legislative campaign committee that establishes a segregated fund to report the activity and cash balances of the fund separately.
Thank you. Let's do a roll call vote on this one.
And is there a second to that motion?
Yeah, there was.
Judge-
Judge Freilich.
Judge Freilich seconded it.
Well, do they have to report it to the board?
Yes,
Where would they report it?
they would report it
The
to
motion
us.
say that?
Well, I think it's implicit if we're asking them to report it, that it comes to us.
Okay.
The statute requires them to file reports with us, so I don't think we need that level of clarification, Judge.
Okay.
Any other discussion before Kevin calls the roll? Call the roll, please.
Judge Leineweber,
Aye.
Judge Mannion,
Aye.
Judge Nickel,
Aye.
Judge Freilich,
Aye.
Judge Frankie,
Aye.
Judge Volke.
Aye. It passes 6-0. And I think that takes us up to per diem payments. As I was telling Judge Lenneweber, I've never seen so few pages sent to us in advance. So he can expect more in the future. But I don't think we need, it's just my opinion, I guess maybe somebody else has to make the motion. I don't see.
I
any-
move we authorize a half-day per diem for preparation and the meeting.
Total of a half a day for both together? Or are you saying?
Correct. Correct.
Barely seconds.
Okay.
All those in favor, say aye.
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 Aye, any opposed? Passes 6-0.
Do we have to submit a request for payment, or
No,
is that done automatically?
we will process that through our payroll system, which, and just as a forewarning for board members, is in a state of transition, and so it's not unusual. I'm getting notices, for example, that say that I have certain employees of mine who have not reported any time, and they happen to be Judge Deininger, Judge Brennan, and Judge Kane, who, for some reason, the system doesn't know, no longer are eligible for per diem payments.
And I don't think we got paid yet for the last meeting.
Yeah, so there's a process, so,
We requested it.
Oh, I know,
yeah.
I know. Okay. We're anticipating feverishly the director's report.
Well, that was essentially the director's report. Unless there are any additional questions about transition activities or preparations, our next meeting is March 1st. And we will keep you apprised of developments as we move through that. There's a lot of training and implementation going on as we are now into the presidential election year, our first full election with photo ID in the February spring primary. So unless you have any specific questions, we would be prepared to go into closed session.
Is there a motion to go into closed session?
Judge Nickel, I'll move, we go into closed session.
Is there a second?
Mannion, second.
Take a roll call, please.
Judge Lineweber?
Aye.
Judge Mannion?
Aye.
Judge Nickel?
Aye.
Judge Freilich?
Aye.
Judge Frankie?
Aye.
Judge Volke?
Aye. So let's take a 10-minute break. We'll reconvene at 20 minutes after 10.
You can either call back in or you can stay on the phone for 10 minutes. We just need to allow Wisconsin Eye to break down their equipment and to clear the room of the press. Yeah, we're going to forcibly evict the press. Okay.